Hello viewers, welcome to my channel. I'm Hasham. So in this video, I'm continuing the last topic, that is free consent. So in the last video, I have explained you the essential element of a valid contract, that is free consent. Without free consent, the contract will be invalid. So what is the meaning of free consent? What are the errors which affects free consent, like coercion, undue influence, fraud, misrepresentation, mistake? These are the causes which affects the free consent. So I have explained you two topics, that is coercion and undue influence, in the last video. The remaining, that is fraud, misrepresentation and mistake, I am going to explain in this video. Apart from that, some practical problems on free consent I am going to explain in this video. So watch the video till the end. And if you have not watched the last video, you may not be able to understand this. So I suggest you to go to the playlist of my channel, select the subject business law, select the topic free consent, watch the first video, then only you can be able to understand now. Now before starting the fraud, next one is fraud. But before starting the fraud, I will explain you the differences between coercion and undue influence. Very frequently in examination you may be asked the differences between coercion and undue influences. Both these will affect the free consent. When a contract is affected, that means affected on account of coercion or on account of undue influence, the contract will become voidable. The contract will become voidable. So what are the actual differences between coercion and undue influence? One by one. It's a physical force or violence. Coercion implies a physical force is applied, violence or threat. So whenever a physical force is applied, violence is applied, threat is applied, then it is called coercion. Whereas in case of undue influence, there is no physical force, there is no violence, there is moral influence. There is moral influence due to the relationship between the parties. That is the first difference. Second one, committing or threatening to commit an act forbidden by IPC, Indian Penal Code. In case of coercion, it's an act. Or threatening to commit an act forbidden by the Indian Penal Code. The Indian Penal Code has listed down many acts which are forbidden, like murder, suicide, kidnap, etc. These are the acts which are forbidden. So these are the offenses. If a person has done this offense, he will be prosecuted, he will be punished by law according to Indian Penal Code. But there is no such act which is forbidden in case of undue influence. Dominating the will of a person amounts to undue influence. So in undue influence, there is no act which is forbidden by Indian Penal Code. There is dominating the will of one person by the other person by taking the advantage of his position. Next one, it's a type of offense or crime. In case of coercion, it is an example of crime. It involves a crime, offense, which will be prosecuted. He will be punished by law if a person applies coercion. Whereas there is no offense, there is no crime in case of undue influence. It is not considered as an offense. It can be used direct or indirect. That means coercion can be applied either by the parties to the contract, or a third person can also apply coercion. Whereas in case of undue influence, there is no outside party. The undue influence will be only between the parties to the agreement. That's it. Last one, it is not necessary to prove that there was a previous relationship. Relationship is not at all required in case of coercion. It is not necessary that the parties should be in a certain form of relationship. Even without relationship also coercion may be applied. Whereas in case of undue influences, it's a must. There must be some relationship, whether it is a real relationship or apparent relationship or judiciary relationship. But any relationship must be there between the parties. In case of undue influence. So these 5 points you can write in examination regarding the differences between undue influence and coercion. Now the next is fraud. See here, a contract is said to have free consent except in the following cases. The following cases are coercion, undue influence, fraud, misrepresentation, mistake. By these 5 causes the consent will become vitiated. So already we have completed coercion, undue influence. Now fraud. What is fraud? Deceiving a person by any means. Remember the wordings, because this is a business law, and in law you have to give more weightage to the wordings. You cannot write in your own words. You have to remember the words of the law. So here, deceiving a person by any means can be treated as fraud. Wordings you remember. Deceiving a person by any means. By any means, if one person is deceiving the other person, it involves fraud. When a person obtains the consent of another person by deceiving him in respect to the subject matter of the contract, the consent is said to have been obtained by fraud. One person is deceiving the other party in order to get the consent from the other party regarding the subject matter of the contract. Subject matter of the contract. For example, A wants that B should accept my offer. A wants that B should accept my offer. That means A says, I want the acceptance from offer. I want the consent from B. So he is deceiving something. He is showing some false representation to B so that he can be able to get the consent from B. He wants to deceive B. That is a fraud. That is a fraud. Now, according to section 17 of the Indian Contract Act, so section 17 defines the meaning of fraud. What is that? Fraud means and includes any of the following acts. See, the definition is not exclusive. It is inclusive definition, because it is not saying fraud means this. It is saying fraud means and includes. And includes means apart from the given list, other items may also come under the category of fraud. So it means and includes any of the following acts committed by a party. Any of the following acts committed by a party to a contract or by his agent with an intent. Why he is committing this act? Why his agent is committing this act? In order to deceive the other person. In order to get the consent of the other person by deceiving him. So intent to deceive another party thereto or his agent and to induce him to enter into a contract. By deceiving, the one person is inducing the other person to enter into a contract. So what are the acts of the person which are treated as fraud? First one, the suggestion as a fact of that fact which is not true by one who does not believe it to be true. A person is showing a wrong information to another person in order to get the consent. In order to get the consent. For example, A knows that this statement is not true, that this act is not true. He knows it, but intentionally he is asking Mr. B to enter into contract. He wants to deceive B in order to enter into a contract. So it is called a fraud. Simple, one of the famous example is a person discloses that the age of his son is 24 years in a marriage agreement. In marriage agreement, a person discloses the age of his son as 24 years. But later on it was found that the age of the son is not 24 years, he is more than 40 years. Later on, the bride's father has put a case against him to stop this agreement. To stop this agreement, the court interferes and says that it's a fraud, because willingly the father of that person willingly has shown a different age. Actual age of this son is more than 40 years, but he disclosed it as 24 years. So this is fraud. This is fraud. Secondly, active concealment of a fact by one having knowledge of the fact. Actively concealing the fact regarding the subject matter of the contract. When one person wants to enter into a contract with another person, he must disclose all the facts of the subject matter. If deliberately, if he conceals any fact of the subject matter, that also amounts to fraud. Third one, a promise made without intention to performing it. A promise made by a person without having intention of performing it. He does not have any intention to make performance, but still he is promising. That is also a fraud. Next one, any other act fitted to deceive. So income tax, this Indian Contract Act has made a wide definition of fraud. It includes any act made by one person in order to deceive another person, in order to get the consent of the other person to enter into contract. Last one, any such act or omission which law specifically declared to be fraudulent. A number of laws in India has given that these are the acts which are fraudulent in nature. So these acts are completely fraud. Example, a person entering into an insurance policy contract. A person wants to enter into a contract with the insurance company. He wants insurance policy, but he has not disclosed the complete facts of the life of the person, of the life of the insured. Mr. A wants to enter into an insurance contract. So he has not disclosed about the health status to the insurance company. That is a fraud. Apart from that, a number of instances are there. Example, in case of marriage contract. In case of marriage contract, it is compulsory that the bride and groom, both health situation, both real status should be disclosed. Otherwise, it will be a fraud. So many cases are there where law specifically says these are the acts which are fraudulent in nature. So this is the complete discussion about fraud. So far we have completed coercion, undue influence and fraud. Next is misrepresentation. This is also one of the error which affects the free consent. What is misrepresentation? When a person obtains the consent of another person by making a false suggestion without any intention of deceiving the other party is known as misrepresentation. Here also one party of the contract is giving a false representation to the other party, but without intention of deceiving. If intention of deceiving is there, then it will be a fraud. If no intention of deceiving the other party, he is making a misrepresentation, but his objective is not to deceive the other party. It is called misrepresentation. So according to section 18 of the Indian Contract Act, misrepresentation means and includes, again the definition is inclusive definition. Not only this, a number of other acts will also come under misrepresentation. So what are the acts? The positive assertion in a manner not warranted by the information of the person making it, of that which is not true, although he believes it to be true. Suppose Mr. A says to Mr. B that this is a fact. Reality, it is not true, but he believes it to be true. Mr. A believes that statement to be true. So, not willingly, he has disclosed this fact to Mr. B so that Mr. B should enter into a contract. It is called misrepresentation. Next one, any breach of duty without intention to deceive. Any breach of duty. So there are some duties of both the parties to a contract. Suppose if there is a breach of duty by one party, but not to deceive the other party. But this breach of duty is not to deceive the other party. That is also misrepresentation. Innocently causing a party to an agreement to make a mistake as to the substance of the contract. Innocently, that means taking the consent of the other party so that the other party can commit a mistake. So these are the items, these are the acts which amounts to misrepresentation. Now what will happen if there is a misrepresentation? The person who was misrepresented can be able to avoid the contract. The contract will become voidable to the party whose consent is taken by misrepresentation. Example, A have misrepresented B. Now B is having the power to avoid the contract. It is voidable contract in the hands of B on account of misrepresentation. The last one is mistake. The term mistake is used to mean improper understanding about the subject matter of the contract. if there is misunderstanding about the subject matter of the contract, that amounts to mistake, right? So when an agreement is made with a mistake regarding the terms and conditions of the agreement, there will be no consent between the parties. This last item, mistake, is a peculiar error of the contract, where if there is a mistake in understanding of the terms and conditions on both the parties, then the contract will be completely void. It is not voidable. The contract will become invalid because there is a mistake, there is a misunderstanding regarding the terms and conditions between both the parties. Then the contract will become void contract, invalid contract, not voidable contract. So here the mistake can be classified. The mistake can be classified as mistake of law and mistake of facts. The mistake of law, for example, a person entering into a contract with another person does not know about the terms and conditions and law of the Indian Contract Act. A person entering into a contract but doesn't know the law regarding contracts in our country. In our country, what are the rules and regulations about the contract? He doesn't know. So he is committing a mistake. This is called national law. But national law is not excusable because there is one saying, ignorantia juris non execuset. Ignorantia juris non execuset. Ignorance of law is no excuse. So when a person says, I don't know about the Indian Contract Act, that's why I entered into an agreement, he cannot be excused because everybody must know the law regarding contracts. But in case of foreign, mistake as regarding the foreign law, a person can be excused. For example, a person in one country enters into a contract with the person of another country, but he doesn't know the law of that country. So he can be excused, provided it should be a civil in nature. The error, the mistake should be civil in nature. Then he will be excused because he does not know the law of that country. Everybody must know the law of our own country, but other countries' law you may or you may not have. So if you don't have the knowledge about other countries, you may be excused, provided it's a civil mistake, not a criminal mistake. Next comes to mistake of facts. Mistake of fact. The mistake of fact regarding the subject matter of the contract. Now it may be a bilateral mistake or it may be unilateral mistake. If it is a bilateral mistake, the contract itself will become a void contract. Bilateral mistake. For example, A says to B, will you purchase my horse at rupees 5,000? B says, okay, I will purchase your horse for rupees 5,000. Both have agreed into a contract. But without the knowledge of A and B, the horse was dead one day before. One day before, the horse was dead. That means the contract is a bilateral mistake. The contract is affected by bilateral mistake. The contract is void contract. When both the parties does not have any information about the subject matter of the contract. Unilateral mistake, that means the mistake is only at the point of view of one party, not at the point of the other party. Then it is a voidable contract. It is not void contract, it is voidable contract. If one of the party is at the mistake, the other party is not at the mistake, then it will be called a unilateral mistake. So I have completed the topic of free consent. I have explained all coercion, undue influence, fraud, misrepresentation and mistake. In examination, you may be asked a theory question regarding what is free consent, how the free consent will be affected, and what are the differences between coercion and undue influence. What do you mean by fraud? What do you mean by misrepresentation, mistake? Like this theory question may be asked. Apart from that, problems may be asked in examination regarding this free consent. So I am starting the problems on free consent. I have provided these problems in the link under my description. So take a printout of the problems before watching this video so that you can understand the problems on free consent. The first problem. Amir applied to a banker for a loan. See carefully, listen carefully. Amir applied to a banker for a loan at a time when India is passing through a period of recession Depression. The banker agrees to make the loan only at an unusually high rate of interest. Amir accepts the loan in these terms. Subsequently, Amir pleads that the contract has been procured by exercising undue influence. Will this plea succeed? First of all, undue influence will arise when both the parties are in some relationship. Here there is some relationship. The relationship is lender and borrower. The banker is the lender and Amir is the borrower. So there is relationship. One party is in a dominating position to the other party. Who is the dominating? Banker has a dominating position. But here, according to the contents of the problem, in the usual course of business, the banker may charge an unusual high rate of interest because due to depression. Due to depression in the economy, the banker is charging a little bit higher rate of interest. So it's a normal business course of action. It is not undue influence. So if Amir goes to a court of law, if Amir sues the banker, the court will dismiss the case, saying that there is no undue influence applied by the banker. The banker has applied unusually high rate of interest because of the conditions. The banker has the right to apply higher rate of interest. That's it. Next one is Kumble. Kumble agrees to buy a motor car from Yuvraj for rupees 50,000. So Kumble agrees to buy a motor car from Yuvraj for rupees 50,000 and pays half the purchase price in advance. 25,000 advance money has been paid by Kumble to Yuvraj. Unknown to both the parties at the time of making contract, the car had been destroyed by the accident. Advice Kumble. So without having the knowledge to both the parties, the car was destroyed in an accident. That means the subject matter of the contract was finished without information to both the parties, buyer and seller. So what Kumble can do? Kumble has to recover the advance given to Yuvraj. Kumble has given an advance money of 25,000 rupees to Yuvraj. Now he can get back his 25,000 rupees from Yuvraj. The court says that the contract will become void because the subject matter was completely destroyed. Next one. Salman was suffering from some disease and in great pain. A doctor agreed to treat him provided he signed a promissory note of rupees 8,000. Salman did so. After recovery, he refused to honor the promissory note. Decide whether he can refuse? Yes. There is a fiduciary relationship between a doctor and a patient. The doctor is in a dominating position, dominating the will of the patient. So here Salman is the patient. He wants the treatment. The doctor says, make a promissory note of rupees 8,000 in my name, then only I will treat you. So Salman thinks that if I did not get the medical treatment, I would have died. So he entered into a promissory note. Now the court says Salman can reject that contract, reject the agreement because his consent was taken under undue influence. The consent of Salman was taken under undue influence. So Salman can avoid the contract. The contract is voidable in the hands of Salman. Next, fourth, Shahrukh buys from Saif. Shahrukh buys from Saif a painting which both believe to be the work of an old master and for which Shahrukh pays a high price. The painting turns out to be only a modern copy. Discuss the validity of the contract. So Shahrukh and Saif, these two persons enter into a contract to buy a painting. They believe that it is an old master painting. But in reality, it is not old. It is not old. It's a modern painting. So it's a bilateral mistake. It is a bilateral mistake. So when there is a bilateral mistake, the contract is void. The contract is void. Next one. Fifth problem. A young widow was forced to adopt under the threat of preventing the body of her husband who had just died from being removed for cremation. Is the adoption valid? Already I told you this case. A young widow, her husband died recently. That young widow was forced to adopt a boy. If she doesn't adopt the boy, no cremation of her dead body of her husband. Then what will happen? The young lady has agreed to adopt the boy. So the court says, that means the consent of young lady has been taken by coercion. By coercion. How coercion? Because if she do not adopt the boy, the body of her husband will not be cremated. Will not be cremated. So it's an offense. To prevent the body not to be cremated is an offense. So there is an offense which is forbidden by the Indian Penal Code. So it's a coercion. So the widow can avoid the contract. The widow is not bound by the agreement. Sixth problem. A spiritual guru induced his devotee to gift to him the whole of his property in return of a promise of salvation of the devotee. Is the agreement valid? No. Undue influence. Because there is a fiduciary relationship between the spiritual guru and the devotee. Spiritual guru and the devotee, there is a fiduciary relationship. That means spiritual guru will have a dominating power to get the will of the follower, devotee. So in this case, spiritual guru has taken the consent to get all the property of the devotee to give him salvation after death. So it is an agreement which is caused by undue influence. So devotee can avoid the contract. Next, seventh. In a case, the consent of Seshamma was obtained on a document and transfer of property by her husband, threatening her that he would commit suicide. The property was transferred to his brother. Later, Seshamma wanted to avoid the agreement of transfer on the ground of coercion. Can she do that? Yes, she can do. If there is a threat of an act which is the forbearance, that means it is forbidden by the act. Threat to make an act which is forbidden by IPC, Indian Penal Code. So Indian Penal Code says suicide is an act which is forbidden by law. It's a crime. So here Seshamma has given the property transferred to another person on the threat that her husband will make a suicide if you do not sign the agreement. So it is a contract which is given by coercion. So Seshamma can avoid the contract. Last one, in case an accountant of a trader obtained his consent on a no objection certificate for relieving him from a job unconditionally by detaining books of accounts of his business. Is this agreement valid? No, the agreement is not valid because he got the no objection certificate by applying undue influence. That's all. So these are the problems on free consent. So in these two videos, I have completed the topic free consent. I have explained the complete theory and I have explained the problems. Now, if you watch these two videos, definitely you can be able to attempt the theory question on free consent and also on problems. Inshallah, in the next video, I'll start the next topic on this Indian Contract Act. So if you are satisfied with my lecture, give a like to the video. Share my channel in your group, in your friend circle so that more students can watch the video and enhance the knowledge. Subscribe my channel if you have not yet subscribed. Inshallah, I'll continue in the next video.